Hey, good morning, everyone. In history of the U.S. Constitution, we're going to segue into a discussion of Article 1. We already went over the preamble, talking about the aspirational framework of why the government's going to exist and what its purpose is for. And I think most importantly is that it stems from the power of the people. The people are the sovereign, where sovereignty rests with, and it is conveyed into the form of government by the people and of the people. But Article 1 is the legislature. And I was just thinking about when I was in law school or even undergraduate, I always, not always commuted, but I often commuted to school. And my father would always say, "What'd you learn today at school?" And I always said, "Nothing." My kids say the same thing when I hear them come from home from school. But if it's one thing you can really ingrain in your memory, and I'm not a big fan of always rote memorization, just memorizing something so you can spiel it back word for word. I want you to memorize it in terms of context and in terms of meaning. But one of the most important things is to remember the first three articles of the United States Constitution. Article 1 is the legislature. And what's the function of the legislature? To make laws. Article 2 is the executive or the presidency. And the presidency's main focus is to implement laws or enforce laws. I know both offices have a broader realm than that, but I want you to get the fundamentals. In Article 3 is the judiciary. And the judiciary's main function is to interpret and apply law in a judicial forum or in a courtroom. So those are the fundamentals. The book, Linda Monk's book, which I think is fantastic, starts off with giving you the dry Article 1. This is what the Constitution actually is. You should read it. And I have to admit, it's a bit, it's dry. You're reading through terms of art. And what it actually means sometimes is very clear. Other times it's a bit subject to contextual application before you understand what it actually means. But you should read through it, plow through it, and you might want to read it outside the book by reading the link I put up from the Cornell Law Institute, because they not only put up the Constitution, they put up summary discussions, if you will, of some of the amendments that altered portions of the Constitution as you go through it, but also they put points of explanation along the way that are very well written and I think very correct, which is the most important, right? But as I start off, we know there's going to be parts of Article 1. Article 1, Section 1, Article 1, Section 2. But Article 1 just talks about the fact that what is the legislature? It's going to be that all legislative powers, meaning the power to create law, shall be vested in one Congress in the United States and shall consist of a Senate and the House of Representatives. We know from the previous material that that was one of the great compromises in creating a constitution. Our federal government was not going to be unicameral, just one legislative body, because there was concerns over large states thought they should have more representation in the legislature. Small states say we're not even going to join this new federal government, if you will, if we're going to lose some of our state sovereignty to the larger states. So the compromise was bicameralism. You should know that term for the test. Bicameral means two bodies or two branches within one house. The House of Representatives would be made up based upon population. So larger states would get more representatives. And the people would vote for them directly. Which people? The states. And it says right here, electors for each state shall have the qualifications requisite for the electors of the most numerous branch in the state legislature. What that means is that who gets the vote? The states determine who gets the vote for your members of Congress, the House of Representatives, but not the United States Senate, which is the upper branch. We'll get to that in a second. We do now, but not then. So large states are fat and happy. They've got a lot of representation in the House of Representatives, the most representative body because it's directly elected by the people who are eligible to vote. And we know in our early inception of our country, that was a very narrow group of people, white, fairly middling at least, meaning fairly wealthy. They had to have either paid taxes or own property in order to participate in their civic life early on. We know we've become much more democratic, and not only do almost anybody who's over the age of 18 can participate in federal elections. There's a few disqualifications, but very few. So we've become more democratized over time. So going through the dry aspect, I just want to focus on a few. One is the federal government doesn't determine eligibility to vote. for the most part. There's a couple of amendments to the United States Constitution that lowered the age to federal elections to the age of 18. And we also know that it banned discrimination on race, also granted the right to women under women's suffrage to vote. So for the most part, voting, though, in terms of eligibility, is determined by the states with certain limitations. The federal government banned the poll tax, for example. It was basically denying the poor the right to vote, and it would limit certain political constituencies based upon that. So the federal government does have some say now and over time over eligibility to vote, but initially it was the states that determined who could vote and when and under what circumstance. The next thing I want to talk about as I go through the dry aspect of it, the Congress itself, the House of Representatives, does have the power to evict or expel its own members, and it has to be done by a concurrence of 2/3. That's a very difficult margin to meet, 2/3 to kick somebody out. And they can just kick somebody out because they think they're, obnoxious, for lack of a better way of saying. There's nothing in the Constitution that says it has to be a high crime or misdemeanor for expulsion of a member. They could just feel the member is being difficult or problematic. We have some discussion about that right now. There's certain members of Congress that are viewed as kind of pariahs. Is there a way to get them out besides voting? And that's the reality. We're not going to expel too many members of Congress in the sense in the House of Representatives being a 2-year seat. And that's another thing that's in here. They run and preside for 2 years. If they die in office or resign while they're in office, they can set up a special election in the home state to fill the seat, which is sometimes done. Depending on if already half the term is gone, many state governments decide just to wait to the election and have the seat open for that period of time. But anyways, that's how that's determined as well. You can expel members of both the Senate and the House by 2/3 vote. It's rarely done, but sometimes conduct is so very egregious that you feel, whether it's criminal behavior or something else, that they should be expelled, 2/3 vote. The one thing is, it's kind of a trivial pursuit question, but bills, which are potential laws, right, they have to go through the legislature. And this is something I want to stress that the book suggests, but I wish it was a little stronger. When the framers were framing the Constitution, they were afraid of tyranny in the hands of either one group or an individual or a small handful of professional politicians or wealthy people, although they were wealthy people themselves. In order to disperse power, to keep power from amassing too much in any one group, we know they created these checks and balances, which we'll talk about later. But in this instance, they wanted the legislature to be the most important branch. And I don't know about you, but whenever I was told in grade school, usually the people that taught civics in my school were also the gym teachers. No offense to gym teachers. But the reality was I didn't think they were always that skilled. And what do they always teach us? 3 co-equal branches of government. I don't think they ever had an intention to make them equal. They meant to have them have checks and balances upon each other with certain spheres of influence and power, but they weren't intended to be equal. I don't know where that comes from, but it's often said. I even hear politicians and lawyers saying 3 co-equal branches of government. It's a terrible, terrible misstatement of law and history to suggest that there were 3 co-equal branches of government. What branch was supposed to be the most significant, the most salient, the most important? The lawmaking branch, which was the legislature, the Congress. So the trivial pursuit question I refer to as a bill, potential law, can either start in the Senate or it can start in the House of Representatives. Either, but in the end, both have to vote on it and approve it before it gets to the president for either approval or veto. And there's a couple ways they can approve and a veto, and I'll get to that when I get to Article 2 next week. There's one exception, and this is the trivial pursuit question. All bills designed to raise revenue, taxes, right, must start in the House of Representatives. It's kind of a trivial pursuit question because does it really matter in the end if the Senate has to approve the same bill in order it becomes law? Yeah, it's just the inception, the way in which the bill starts. It simply has to start in the House of Representatives because when it comes to taxation, there's not a more representative body at the time of the inception of our Constitution than the House of Representatives. So bills to raise revenue, taxation, have to start in the House, but the Senate still has to approve it. And there's language in here what happens. They go through both the House and the Senate and they can't agree, then they have a special committee to hash out the disagreements it gets proposed again. And many bills, and this is part of the checks and balances. When we get to the exam, I'm probably gonna have an essay question about, what are the checks and balances that our framers put in the Constitution. A lot of people say, well, the president can veto the legislature can override the president, that the president has certain appointments or treaties they want passed, and the Senate has to agree with it. The judiciary is picked by the president, but the Senate has to approve their choices. There's all these checks and balances, but there's inherent checks and balances within the legislature itself, in that the House of Representatives has to agree with the Senate. But what's the other checks and balances within it? There are internal rules upon the process of which a bill gets introduced and goes through subcommittees and ultimately approval to be voted on by the entire membership. And there are tools in which committees can kill bills. And I hate to put it up because I think it's almost kind of infantile, but when I was a kid, there was a thing called Schoolhouse Rock, and there was a pretty decent, and still decent, but I feel silly putting it up. And it's called I'm Just a Bill. And it's this guy that's like a rolled up piece of paper, and he's talking about how he's going to be introduced to Congress. But he does mention along the way that he could die in committee, or they could recommend further study on it. These are internal methods by which bills don't become laws. And I think our framers intended that. There's not necessarily always a need for new laws. In fact, there might be even a need to get rid of some of the laws we have. And the framers recognized that. They didn't want to rush to the ability to come about, to create laws just on the heat of the moment. And I read a great discussion. I don't know why it was reduced to writing, but supposedly George Washington was talking to Thomas Jefferson, who was the Secretary of State at the time. And Jefferson was a little bit frustrated with the way in which Congress was difficult to get a bill through. And George Washington says, "Why do you pour your coffee into your coffee saucer?" And he said, "To cool it down." And he says, "That's why we have two branches of Congress, to cool down legislation, to make sure it's just right for the American people before it becomes law." I don't know if it's true, if that was said, or if it's, but I've read it in a few different places. Supposedly that discussion took place, but it's true. There are checks and balances within the two branches of government in the process by which a bill gets ultimately proposed as law. And when different legislative interests debate and add and take away from, we know that sometimes bills die along the way because they get so mutilated that what they started as don't come out the same way, or they basically die on the floor. Looking for so many things I underlined I thought was important. Oh, there's another compromise in here, is how do we count people? And we do a census, and it's called the 10-year decennial census every 10 years. The big controversy were there. Southern states wanted the African slaves. They didn't call them slaves. They called all other people. They wanted them to be counted as part of the head count, so they'd get more members of the House of Representatives. The North, not necessarily in opposition of slavery. Some of the people were because of opposition to slavery, but others just simply didn't want the South to have that much influence in the new government because there were sectional differences in terms of influence and political power. And so that debate raged on. And what was the first compromise there? The 3/5 clause. Slaves would be counted as 3/5 of a person, not because of their value as human beings, but simply for purposes of head count. So every time you have 5 slaves, it would equal 3 members of the community for purposes of how many representatives you have. Initially, we started off with having 30,000 per member of the House of Representatives you represent. That was initially in the Constitution. That got amended. Now we've just basically capped it off legally to have 435 members of the House of Representatives. But because the population's grown so much, we now have each member of Congress, the House of Representatives, roughly has about 750,000 citizens or residents under their auspices, if you will. If we kept the old rule of 30,000, we'd have, like 10,000 members of the Congress, and that wouldn't be too cool. Way too many. They're responsible also, and then the one I think is not the most important, but most people think is most important, is we wanted to create a government of limited authority to only have certain things you can do. And so in Article 1, they've created Section 8. Article 1, Section 8 basically says this is the power of Congress, and you have no other powers at all. It's a government of limited authority. The big ones they were trying to fix from the Articles of Confederacy was the ability to raise money to regulate commerce. and maybe some could argue a third one was to raise standing military and Navy and military and things of that nature. But they have the list here. It's Article 1, to borrow money, to regulate commerce with foreign nations, uniform rules of naturalization and immigration, to coin money. You don't want different. I got money from Connecticut. You got money from, from Vermont. Well, actually, Vermont came much later, New Hampshire. But you get my point. Create post offices. To create courts inferior to the superior court. To declare war. Trivial pursuit questions. When the last time the Congress declared war? World War II. We've had many other wars, but we have created a different mechanism by which conflict is resolved, basically through the coin purse. Congress pulls back money if they don't like the conflict the president has entered into, but I'm way off track on that. And it talks about all the things the power will have, the power of the Congress will have. Now, that is dry as hell. Right? When you read through the document itself, what does it actually mean? The other thing that I didn't touch upon is, okay, so House members, here are the rules too. This is test material, right? You have to be at least 25 years old. You have to remember back in 1787 when this was being debated and ultimately adopted in 1789, 25 years old was, kind of middle age in terms of, you're out in the world with a certain stake in society. You should kind of know what's going on. But you also had to be a citizen of the United States for 7 years. So 25 years of age, and you had to be a citizen for 7 years. The Senate, and then if you run and you win, you serve a 2-year term. Every member of the House of Representatives does a 2-year term. Everybody's up for election every 2-year cycle, all 435. There was a big debate initially. Some people say, we want government to be so responsive. We want to be able to throw these people out of office if they're not responsive to the people that they represent. They wanted a 1-year term. But others said, we have to get some consistency and some degree of stability, and they wanted 3 and 4 years. And so the compromise was 2-year terms. So all you have to be is 25. You have to be a citizen of the United States for 7 years. You ultimately do have to reside in the state, but not necessarily during the campaign. But once elected, you have to reside, have a residence within the congressional district from which you reside. The Senate is different. The Senate, up until 1913, was actually picked by your state governments. A lot of people don't know that. This is constitutional history. You should know it. The framers didn't trust direct democracy, didn't trust the middling people to participate in choosing wise government. And so they tried to create a balance. And part of the checks and balances would be the Senate would be considered to be more an aristocratic body, a more knowledgeable body, a more senior member. And so therefore it was 30 years of age. The next is your state legislatures would pick the senators from each state. And again, the great compromise is small states weren't happy with the way in which the representation was done with the House of Representatives. Based upon population, small states are getting screwed. They made it bicameral by making the Senate equal across the board, meaning if you were tiny Rhode Island or Delaware or Maryland, you'd get 2 senators just like Virginia, Pennsylvania, New York, and Massachusetts were at the time the bigger states. This was the great compromise, but also the check on mob rule, pure democracy. Pure democracy was not popular in this era, was to have the state legislators who would be more what? More knowledgeable about the ongoings of public affairs in the moment to pick the community leaders that would most be responsible and do the good job, initially in New York and then later in Philadelphia and then ultimately in Washington, D.C., but that they would do a good job. And it would be a 6-year term. And the initial Constitution staggers it. Why does it stagger it? Meaning that we don't want the entire United States Senate up for election every 2 years or every 6 years so it could clean house. We want to create a stable branch, and therefore the initial election, some 1/3 of the country would be up for a 2-year seat, 1/3 of the country would be up for a 4-year seat, and the last third of the country would be up for a 6-year seat. Then, upon the 6-year cycle, all those staggers would go out. So every 2 years, 1/3 of the senators are up for election for a 6-year seat. That sounds a little convoluted. Basic math, you get it, right? If you win, you get 6 years, but your other member of the U.S. Senate from your home state won't be up in the same election cycle. They're staggered. 1/3 of the nation every 2 years is up for election. And when they win, they get a 6-year seat. It's a little different in the Senate if a senator should die or if a senator should quit. and it does happen, how do we replace them? Well, in the legislative branch of the House, we know that they can set up a special election, but they don't have to in the home state of the congressional district. On the Senate level, the governor of the state can pick a successor to fill out the remainder of the balance of the seat, or they can decide to set up a special election. And that's what just happened down in Georgia. One was up for the normal election. The other was to fill the unfulfilled seat of a recently deceased member of the United States Senate. So it's fascinating to me. I think it's a good idea, because think about it. What if every 2 years we can get somebody say, "That's great, let's get rid of all the Congress." There is that attitude, right? But if we throw everybody out, all 435 House of Representative members, all 100 of 50 states, 2 for each state, all 100 of the United States senators, all in one election cycle, that would create a great deal of instability. And the reality is we don't tend to throw out incumbents anyways, but imagine if it could be that. I think the framers really had a nice forethought here to say, we're going to create a more stable body in the United States Senate. But what wasn't very democratic was we didn't get the vote for them directly. It was the state legislatures that would pick U.S. senators. Up until 1913, it's the 17th Amendment. I always found this very, very curious, because if you see the stuff behind me, I'm a political junkie. Maybe I didn't always dream it. As a kid, you want to do different things, and I had maybe 100 different dreams. I'm like one of those people. My brother's been diagnosed with adult form ADHD. I probably have it too. But one of the things I wanted to be was I wanted to be the U.S. Senator from Massachusetts for a long time as a kid growing up. And part of the reason I went to law school was because I found out that a lot of senators happen to have law school pedigrees as part of their degree thing. But it was interesting to me that I always thought, we're fighting for democracy. We're fighting for democracy. The people decide everything. The framers didn't want the people to decide everything. They wanted a lot of checks and balances, especially on the everyday people that weren't expected to participate in civic life. We're much more democratic now than we ever today in this year than we ever have been. And arguably 1913 was one of that more democratic moments in our history, because now we could, if you were eligible to vote in your home state, you could now vote for U.S. senators. It was quite controversial at the time. And not too long after that, 1919 into 1920, women's suffrage. Women now could vote nationally in voting. And we know going back to 1868, the 15th Amendment, African-American males could not be disenfranchised. They had to be given the right to vote as well. So over time, if you think about our history from 1787 to today, much more democratic, much more participatory, if we want to. But now she segues. I'm on page 24 of my book. Now she goes over what was meant behind this, what the framers were trying to do. She does interpretive things along the way. And one of the things that she stresses, and I've got to stress for you too, I'm going to put it in the test, the framers of the Constitution expected that Congress will overshadow the newly created executive, the presidency, and the judicial branches. And they spelled out its powers in detail. Where? Article 1, Section 8 is where its powers are. And they believed in separation of powers. Congress has certain powers. Branches within the Congress have certain powers. The executive, the president have certain powers. And the court have certain powers. The powers of the court get developed much later, not so much in the constitutional document. Yeah, checks and balances in Federalist 51. Why do we read the Federalist Papers? Because when the Constitution was being basically sent out to the states for its citizens to vote on, there was two groups, the Federalists and the Anti-Federalists. Federalists wanted adoption of it. The Anti-Federalists said, no way, we're giving too much power to this new centralized government. It's going to be tyranny. They don't have our own local interest at stake. We want local rule. We want states to be the sovereignty. And so we split sovereignty between the state and the federal government. But they wrote these articles called the Federalist Papers, basically propaganda papers that were printed in newspapers trying to sell the merits of the Constitution. And James Madison, Federalist 51, probably the most famous, maybe not the most, but one of the most famous Federalist Papers. Ambition must be made to counter ambition. The interests of the man must be connected with the constitutional rights of the place. The conflicts of the different branches were designed to limit any one group or individual from becoming too powerful. Now, people like to talk about all the checks and balances. I'll refer to a few of those in a moment, but I'm not going to talk about the judiciary because it didn't come about until 1804 or 1803, a little later on. And again, Congress would be the principal arm of government. and they did not want to give it unbridled power like England's parliament. And so what was the bridling power? Enumerated powers. Only has so many powers, and the power of the people to throw these people out of office every 2 years in the House of Representatives, and then later state legislatures being able to throw you out of the Senate every 6 years. Oh, and the only difference, the Senate, you have to be 30 years old. You have to be a citizen of the United States for 9 years, and you ultimately have to have a residence within the state by the time you're elected. And I love the little quote she puts in here about Mark Twain making fun of Congress. Has always been very unpopular. And this is all the way back, Mark Twain, different century, obviously. It says, reader, suppose you are an idiot, and suppose you are a member of Congress, but I repeat myself, because it's basically making fun of it. There's another one by Will Rogers, who was one of my although it was way before my time. I guess my father's hero. But like a lot of people, you start turning into your parents. But my father loved Will Rogers, and he puts a quote in here later in the text. It's a very long chapter. I'm looking for the Will Rogers one. Yeah, Will Rogers. With Congress, every time they make a joke, it's a law. And every time they make a law, it's a joke. I mean, that kind of humor doesn't go too far today, but back in his heyday, the 1920s and 1930s, comedic cowboy actor Will Rogers, he had a lot of influence over American psychology and mood, and he was very critical of Congress. So we were worried about excessive governmental power, put these checks and balances in there. And again, Article 1 lets the states determine the eligibility to voting, and we know that's changed a lot over time. At one time, you had to pay taxes. They used to put in these they are stupid. They're also very inappropriate. There was racial attempts, overtly, it didn't look racial on its face, but the Jim Crow laws, they put in literacy tests, but they let you be grandfathered if you're white. If you're white and illiterate, you could vote if your grandfather was eligible. But if you're black and illiterate, you couldn't vote unless you could pass a literary test. And you can say, well, you can't say my grandfather obviously couldn't vote because he was a slave and he was completely disenfranchised. Those laws are all gone now. And that's one of the things I think is beautiful about our Constitution. When we recognize that things are wrong and that we've treated people inappropriately or unfairly or discriminatorily, whether it's race, sex, all of these different things, we have the ability to correct it through amendment, and we've done it many times. Looking for the things that she stresses. We're going to talk about some of the cases I'm going to post. When we talk about the power to regulate commerce, I think the framers thought it much more narrowly, but we know the court, in interpreting some famous cases, one's the Ogden case dealing with commerce on ferry boats up in the Great Lakes area, and the other is obviously the famous case of Maryland versus McCullough. I'll put those up, and I can talk about them right now. The book does a nice job of talking about some of the people that weren't allowed to participate, including Native Americans, until the middle or the early 20th century, because they were deemed to be a sovereignty of the Indian nation, and therefore they couldn't be members of the United States citizenry for a long time. Surprises a lot of people. One of the things that's still being bantered about right now, Ted Cruz, the United States Senator from Texas, thinks there should be term limits. Many of you probably think there should be term limits. Sometimes because I wanted to be a senator, say I'll never get in, because once you're a senator, you stay a senator, and it's kind of that person's job, it seems like, for life, if they want it. We're here from Massachusetts, and we've had some very long-term senators. If they wanted to stay in power, they could. So sometimes I'm in favor of it, but the problem is it's unconstitutional. The case is Cook v. Gralek, 2001. The Supreme Court said it's unconstitutional for states to try to put limits on the members of the House of Representatives in terms of how long they can be in office, or United States senators, because only the United States Constitution can determine eligibility for those offices. So what Ted Cruz is actually trying to put around is a constitutional amendment. I don't know, 2 terms for United States Senator or 3 terms. Remember, it's 6 years. You'd be in there 18 years if you did 3 terms. In House of Representatives, I think you want to know more than 5 terms, like a 10-year stint. I think it's fairly popular with many people. I don't know if it's popular enough to get 2/3 of the House, 2/3 of the Senate, and 3/4 of the state to approve that amendment. Very difficult to amend the Constitution. I don't think term limits are going to come anytime soon. And to my own, I have mixed feelings about it. Because one of the arguments, if I have a great senator, if I have a great Congress member in the House of Representatives, why shouldn't I be able to keep sending him or her back? Then people say, well, we need change. I don't know, do we always need change? Someone's doing a great job. Don't you keep them on the job? I don't know. And that's the argument back and forth. But what about someone like me? I'm not young anymore, but when I was young and I used to have dreams about, running for office, the roadblock to incumbency, that the seat wouldn't open up and I wouldn't want to run against somebody. And that's still a philosophy. I don't like to run. And I've run for a few offices. When I run, I always like to run for an open seat, because if you run against someone, you have to say, I'm going to do a better job than the person who's in office now. And that's something that's difficult to do. You like to see a seat open up once in a while and see other people participate in our civic life. And those are the debates that go back and forth. But right now, term limits are unconstitutional on the federal level. Yeah, until 1924, Native Americans didn't have the power to even be citizens, never mind participate in a democracy. Redistricting is an interesting. You should know about it simply because many of you are from Massachusetts. Some of you are up in New Hampshire. A couple in Connecticut, I think, in this class. Gerrymandering. Elbridge Gerry was the governor of Massachusetts, and basically, when the census comes out, there now has to be an equal number or close to an equal number of representatives that you'll have. So if I'm a member of the House of Representatives from Western Mass, I have the same number of citizens in my congressional district as you would if you were from Boston. You might have a smaller geographical area because the people are more condensed. But gerrymandering is interesting. If it's done to even cure racial discrimination, it's based upon race and therefore probably unconstitutional. But if it's just done to keep a political party in power, that's probably not unconstitutional, believe it or not. So what is gerrymandering? It's to draw the districts in a certain way to benefit a certain political party or individual for likelihood of being either elected or reelected. And the reason why they call it gerrymandering was Governor Gerry did this to help all of his political allies, and he made this, and the map is in your book on page 33. Somebody put some wings on it and some feet, made it look like some kind of like dinosaur or salamander of some kind. And so they took the name Gerry and mandering into this process of redistricting an area that's so convoluted and so odd that it seems inconsistent with logic, but what they're doing is trying to maintain power. I don't know, if I was a district, I'd like my district to kind of be nice, like, like a shape of a basketball or the shape of an ice cube, nice and squared. I don't want it like slithering up all through these different regions, and I don't represent a more congruous area, but they do it, and they've done it. Democrats do it, Republicans do it. It's not a one-party issue thing. When somebody's doing it, look what the Republicans doing, or look what the Democrats. Both sides have done it many, many times. It's about power. And we know the internal thing that's really in the House of Representatives and the Senate is really big. We know we have the Speaker of the House. A lot of people say, why does Nancy Pelosi get all this news? Nancy Pelosi right now, as I'm making this video, is the Speaker of the House because she has a lot of control over committee appointments and also the ways in which bills are ultimately pushed through or pushed down in Congress. And it's a hugely influential position. So that's part of the checks and balances within the Congress itself, that the way in which the internal rules, including the Speaker of the House's role in the House of Representatives, dictates a lot about power structures. In the Senate, we call them the pro tem. Pro tem right now is a little bit awkward because we have a tie as I make this video. Hopefully I'll use this year after year. But right now we have a tie in the Senate. It's evenly split between Democrats and Republicans. And with that even split, there's a real question of who the pro tem is. Do we keep it as Mitch McConnell, the Republican, or would it be, I believe the choice would, the members pick who the leaders can be. It's not necessarily the most seasoned person or the person that's been in office the longest. The pro tem is picked by the membership of who's going to be the leader of the Senate. And that would be Schumer from New York is likely to be the pro tem if there was a majority. What other powers do the Congress have besides regulating commerce, raising taxes, raising military, declaring war, coinage of money, all those kinds of fun things? They also have the power of impeachment. And it's important because we have a president, although he's no longer the president, but he's now in his second impeachment. And you should know the rules. It's just basic civics, right? It's a government class. What is the power of impeachment? The House of Representatives impeaches. That's simply a charge or an indictment. All it is a mere majority. We now had 3 impeachments of one president got impeached twice, which is historic. But the first one was Andrew Johnson under Abe Lincoln. He was very unpopular, and he was, a better word, kind of a jerk, right? But they didn't really have legitimate legal grounds to impeach him. But he got impeached. The majority of the House of Representatives impeached him. But it takes a 2/3 majority of the Senate to convict. And to convict of what? It's not clear in the Constitution what high crimes and misdemeanors means. Can it be wrongdoing civilly? Can it just be, who knows what it can mean? That's the argument that's stemming around Bill Clinton's second impeachment is what kind of behaviors or incitements could you be responsible for to be subject to impeachment? And I think it's up to the decision of the Senate. So in an impeachment, again, the House of Representatives by majority vote and votes to impeach. And again, a lot of people think Richard Nixon got impeached. He didn't. It was likely he would be impeached. All impeachment, again, is a charge. We've never had a president convicted. Very difficult. And who were they? Andrew Johnson was impeached. He was acquitted by like 1 or 2 Senate votes. Very close. Would have been sad because it would have been really the Congress taking over our entire government because it wasn't on valid charges. I'm way off track. Number 2 is Bill Clinton. And a lot of people think he was charged with having an affair with an intern. No, he was charged with perjury concerning the relationship with the intern in a legal proceeding. The Senate didn't come anywhere near 2/3 to convict, so he was acquitted. And then President Trump, the first time around, which was dealings with Ukraine and maybe trying to influence an investigation into the Bidens or something. The details are pretty mucky, but he got indicted or charged or impeached by the House of Representatives. And the Senate came nowhere near 2/3 voting to expel him. Now, the most recent, over the insurrection. Now, he's no longer the president. Can you still impeach? And that's one of the debates going right now. Is that constitutional? Does impeachment only apply to while you're sitting in office? Or could it apply to after you're done with office? Because one of the things that impeachment does is not only remove you from office if you're in, but it also bars you from serving in any position of elected authority or governmental position. And that's, I think, the argument that those who want Donald Trump to be impeached and convicted would be to bar him from future office. That's, I think, the rationale behind it. Other people say even if they don't like Donald Trump, it's just a waste of time and money. And the reality is to get 2/3 of the Senate, I think even this time go around, is going to be very unlikely. And he's already been impeached, though. He's already been charged a second time. And again, it's part of the checks and balances. If we have, say we did have a president that was really rogue, bigger than that's happened before, we do have a safety valve, a mechanism to get rid of him. Same with judges. Any federal officer can be impeached and removed from office. If it's a sitting president, the trial is done in the Senate and the Chief Justice of the Supreme Court sits as the judge. But it's not a traditional trial. So that's, I guess they're just to make sure the procedural rules are followed in terms of introduction of evidence and arguments. Right now, the sitting judge will be Patrick Leahy from Vermont, the senator. Why? Why not Justice Roberts? Because the Constitution says while sitting as president. Donald Trump's no longer the president, so the rules aren't nearly as clear, and that's why a lot of people debate about whether it's even constitutional to do it. Again, you have to be 30 years old to be a senator, citizen of the United States. Inhabitant, you have to be an inhabitant of that state for which you should be chosen by the time of it. And a lot of people say, well, didn't Hillary Clinton, she lived in Arkansas and all of a sudden she moves to New York to become a U.S. senator? Yeah, many people have done it. It's not that strange in history if you have enough power and the people are willing to support you. And usually citizenship in a state is just determined by a willingness to live there. So I think to become a citizen of Massachusetts, you just basically have to say, I'm moving to Massachusetts. I want to be a United States, Massachusetts citizen. There's no not that I'm aware of, don't quote me on this. I don't know if do you have to live there for a year? Do you have to live? Some states have different rules. But if you look at my political stuff, I collect everything. I don't care what party. I collect enemies of people I admire. I collect people I admire. But I do admire Robert Kennedy very much. And Robert Kennedy, when he was assassinated, he was running for president. But a lot of people don't realize he was a senator. People say, he was a senator from Massachusetts family. No, he was a senator from New York. And prior to that, he was living down in Virginia. And he couldn't stand working for Lyndon Baines Johnson anymore. His brother, John F. Kennedy, was assassinated. So he decided to run against a guy named Keating in New York, and he ran for U.S. Senate and won, just like Hillary Clinton did. So a lot of people call these people carpetbaggers based upon a Civil War phenomenon that a lot of people that were looking for political power went down south when all the Southern politicians were thrown out for participating in the Civil War. And their luggage was made out of these carpetbags, and that's where the term comes from. But this is not unique to any one party or group. People just take advantage of political vacuums when they can. So again, judgment impeaches. I'm not so concerned about the actual election day when they have to seat and the member. That stuff. It's not important. I just don't think it's that critical. The filibuster is. There's a thing called closure that's basically shut down filibuster in a big way. But in theory, you could just keep going and going and going as long as you're physically able and don't yield the field. You could basically prevent a vote from ever coming to place. You could kill a bill that way. But they determined that because it was an abused process, they created this thing called cloture. And so in the Senate, if 60 members out of the 100 decide to close the question, cloture, the filibuster's been overridden, so people don't even bother doing it. If you want to watch an interesting thing about filibuster, it's a great movie. One of my favorite actors, Jimmy Stewart. It's Mr. Smith Goes to Washington, and he does a filibuster, and he ultimately kind of passes out from exhaustion. It's still a tool that the framers wanted to have. A lot of people think it's archaic. I'm looking at the things, raising revenue, things like that. Now the veto. This is part of the checks and balances. Although we're not into Article 2 yet, we need to know that, okay, so the legislature says we got this great law, we want to pass it. They have to send it to the president. It's called the presentment clause. So they present it to the president. The president must sign it within 10 days. If they don't sign it within 10 days and the Congress is in session, it becomes law. So why would the president do that? The president obviously is going to get some advisors. Some, hey, by the way, buddy, if you don't sign this in 10 days, it's going to come law anyways. Sometimes a president is sometimes opposed to very popular legislation, but he or she has a philosophical view against it, so they let it pass through that mechanism. They don't actually sign it. So later they can say, hey, don't look at me. I didn't endorse that. Kind of silly. The other is they could veto it. Veto is a very, very powerful tool. It's a big part of our checks and balances. So the president can say, legislature, what you're doing here, I get it, but it's way too expensive, or it violates some fundamental philosophy that I have as the president, and I think I owe it to the country to veto it. Vetoes aren't done very, very often, but when they are done, often the bill does die there, because in order to overcome a veto, you need 2/3 of the House of Representatives, the Congress, like the lower house, and 2/3 of the Senate, both to agree to override the presidential veto. And the president, when they do veto, is supposed to list or explain their grievances against it. Because sometimes when they go back, they might just write a new bill to edit it to address the president's concerns. But chances are there are always liaisons going back and forth between the president and the legislative branch, talking about will the president likely support this bill or not. So they know at a time that a veto is coming what it's about. The other is something called a pocket veto. This is when the president only has 10 days in which to veto a bill, becomes law automatically. But if Congress adjourns during that 10 days, the bill dies if the president does not sign it. It's called the pocket veto. It's great because sometimes, again, legislation is really, really popular. The president wants it to die, but he doesn't want to do an overt veto of it. They do a pocket veto. So, I didn't get around to signing it. Sorry, I think it just died. I think the public knows that the president was opposed to it. Might as well just veto it. But you should know the rules. I mean, there's little technical rules about timing when it comes to vetoes and or approvals. And now there's a thing that is not too much in this book. It's called signing statements. Sometimes when a president says, okay, the bill came from Congress, they want this law passed, I've looked at it, I'm going to sign it, but I'm going to reserve certain objections to it that I don't think are correctly enforceable or that I don't think necessarily should apply to me. Those signing statements I don't think have any legal bearing, but some presidents think they can argue later on that they may not enforce a provision of that law based upon their signing statements. It's, I think, an abusive process personally, but Democrats and Republicans have both used the tool quite often. The legislative veto. This is a big one. The legislature is the only body in which laws should be passed, but there's so many regulations that need to be dealt, so many things that need to be regulated. It can't all be done through law. So they often create agencies. Agencies will go out and implement regulations related to a certain field of expertise. And by doing that, they're basically giving they're delegating legislative authority. If too much authority is given to a legislative, an agency, a regulatory agency, it is deemed unconstitutional as being a violation of the delegation of powers. But there's a huge amount of agency authority out there, and the legislature always is higher than the agency. So if the agency is doing something the legislature doesn't like, the legislature can go back and rewrite the regulation to bar the agency from doing certain actions. I'm way off track, but it's in the book right here. Dry. And we know that, although we're not getting to the checks and balances right now, we know that the government sometimes tries to get things done with the president's approval, and it becomes law, but we know the other check, but we won't talk about it until we get to Article 3. The court can shoot it down as unconstitutional. And again, a lot of people think, well, the court can shoot it down because it's a bad idea, or it's silly, or it's stupid, or, however you want to frame it. That's not true. The court only finds things invalid and void if it violates the limits in the Constitution. So sometimes they can think it's wonderful, but they'll shoot it down because it doesn't have the enumerated powers in the Constitution to create that area. Same with acts of the president as the executive. And the inverse is true, like Obamacare or the Affordable Care Act. It was a 5-4 decision upholding it as constitutional, not under the Commerce Clause, but under the taxation power to tax. What's interesting about that is John Roberts got a lot of criticism. John Roberts was appointed by a Republican. He was supposed to be conservative justice. Everyone says, oh, he's turned liberal around us overnight. John Roberts said very clearly in his ruling that this is not about the wisdom of the law. Elections have consequences. And as long as the law that gets passed by the legislature and signed by the president is constitutional, we're not here to endorse it, approve it, or say it's great. We're here just to determine whether it's constitutional or not constitutional when it comes to questions of challenging its legitimacy. People get surprised by it. They think, oh, hopefully the court will shoot down this stupid law. They only shoot down laws if it violates the Constitution. Yeah, here's the thing about commerce, which is commerce and taxation are the two most important powers that I think that the legislature has. In the first case is Gibbons versus Ogden. I'll probably put a copy of it up on a blackboard. Chief Justice Marshall, who's the most significant justice of all time, defined commerce power broadly to include transportation, even internal transportation, if it impacts external economic ripples, if you will. And it was a New York monopoly on steamships. Basically struck that down. So only the federal government can regulate commerce between the states. I'm looking at the other big one. And of course, so now back in the it's got to be 1930s because that's when FDR gets elected. 1932, FDR gets elected. The legislature's largely in his favor. So they're passing all these new laws, creating all these new agencies to go out and help spur the economy and hopefully, get us out of the Depression. Those acts, one after the other, kept getting shot down as unconstitutional. Doesn't have the power under commerce, doesn't have the power under taxation. You can't just create laws to help shape economic policy in the country if it's not granted under Article 1, Section 8. And what did FDR do? And this is going to be in the test. FDR did something called the court packing plan. He said, we got a lot of members of the 9 justices that are pretty elderly. They're pretty old. We don't want to be caught in a situation where people retire or die off and leave us kind of in the breach with an ineffective Supreme Court. So I'm going to put 13 members of the Supreme Court. I'm going to put another 4 or 5 up there, and we're going to have maybe 6, and we're going to have a bigger Supreme Court. Who's he going to appoint? Who does any president appoint? He's going to appoint people, one, that he knows the Senate's going to pass. The Senate was in agreement with FDR. He was the most powerful president, I think, in history, more powerful than Lincoln. And because he had the Senate and the Congress in his behalf. He didn't do it. And quite frankly, it was a black eye on his history. Because what did he try to do? He tried to take away the power of the court to be part of the checks and balances because the court wasn't agreeing with him. A lot of people think that position he was taking, that I'm going to put more members on the Supreme Court. There's nothing in the Constitution about how many members there'll be, and I have the power as a president as long as the Senate approves it, put as many members on it as I so wish. Guess what the Supreme Court started doing with the New Deal legislation? It is constitutional under the Commerce Clause. Yeah, it is constitutional under the Taxation Clause. They became more liberal in terms of their interpretation, and many people thought it was under the threat of the court packing scheme. You should know about court packing. It's in the book. It's here. Maybe I'll even put up a little video about court packing. That's beyond me. My little spiel I'm putting up right here. Naturalization, that's an interesting one. Straightforward. She explains it well. Post office. To declare war. And again, we haven't declared war since when? World War II. But the war powers are largely regulated to pulling back the president now after they engage in. They have to act as commander-in-chief in a national emergency, but they do have to consult with Congress immediately within, I believe it's within 24 hours. Navy, Army. I'm not saying this stuff is important. And then the big McCulloch case, Maryland, the Supreme Court ruled the necessary and proper clause. Remember, we got these listed enumerated powers: power to regulate commerce, the power to tax, the power to coin money. And then along comes the national bank. And the case is in 1819. And Thomas Jefferson, no, he's not dead yet, but he wasn't in political power anymore. He hated the national bank. And so did Andrew Johnson. And they hated this national bank. And they said, what constitutional power anywhere does it say the federal government has to create a national bank? And so they sued. And Maryland sued it, went all the way to the Supreme Court. The Supreme Court says, well, wait a minute. You got the power to coin money. You got the power to borrow money. You got the power to tax. You get the power to regulate commerce. Banking goes hand in hand with that. And guess what? There's a clause in the Constitution called, and to enact all laws necessary and proper to fulfill the enumerated powers. That necessary and proper clause has become known as the elastic clause because it really expanded the interpretation of what the power of Congress has done. And I think to the anti-federalist argument, the federal government did expansively grow based upon rulings like Ogden for commerce and McCulloch for taxation and commerce. Just huge. Changed the whole thing in terms of expansive. And John Marshall was the last of the Federalists. Strong central government, big central government. It's the best for the nation. And through his interpretation, he was to get the other 8 members of the Supreme Court usually to go along with him. And he really changed the scope of this country, I think, more than any one individual in terms of constitutional interpretation. Rid of habeas corpus. Some of you are, I don't know if it's this class, but I have a state trooper one class. I have, I think, a deputy chief of police from another town in either this class or another class. What I think is fascinating is that we always think of the Bill of Rights as those things that police and law enforcement have to deal with in terms of unreasonable search and seizures necessary. When is it necessary to get a warrant and due process and having an attorney stuff? But there's some in the body of the Constitution as well, and that's habeas corpus. And we'll talk about Bill of Attainder. It's in Section 9. What's interesting about habeas corpus, sometimes it's called bring the body forth in Latin or show me the body. It gives people the power, whether they're held on state charges or federal charges, to literally fill out this little simple petition to be brought before a justice to have the government justify why someone's being held. And that applies whether or not you're a United States citizen or you're potentially a foreign terrorist. And that's what the government was initially. And people say, why do we have Guantanamo? Why do we keep people down in Cuba? Because there was some thought that the constitutional civil protections like habeas corpus, to be able to present your case to a court to show justification why you're being held and to be told of the charges that are against you or what you've been convicted of, would somehow not be applicable. In that way, would save the government a lot of time and effort in dealing with some of these terrorists. But the Supreme Court has ruled fairly strongly that even these enemy combatants, so to speak, have the power to exercise habeas corpus and the due process of law. If you're subject to the Constitution, you get the constitutional rights. And that was Boumediene versus Bush in 2011, applied to foreign nationals who were seized during war times and held at military bases like Guantanamo Bay. So Guantanamo Bay might still be convenient politically because it keeps them away from the continental United States while they're being held, but they have the same rights now to trial and representation and to have habeas corpus. Now, this one's kind of interesting. Ex post facto and Bill of Attainder laws. These are also under Section 9. A Bill of Attainder is the Congress is barred from creating a law that makes you a criminal just by your existence. So we now make it a crime to be Jim Corman, or an identified group to be a plumber is a crime, or to whatever it is. So no bills of attainder. You can't inflict punishment on a person through an act of legislation without a trial. You can't basically just the legislation. You can't legislate the criminality of a person's identity. We don't talk about too much because they just never do it because they know they're banned from doing it. But the British were doing that to some of the people in colonial America that were in revolt by just identifying them as basically being criminals by their very existence, the Bill of Attainder. The other one I think is more interesting is ex post facto. Ex post facto is you can't have retroactive laws for criminality. And so, for example, what if, I don't know, wearing a blue tie is a crime, and I take it off, and they pass that law next week that wearing a blue tie of this color is a crime. They can't punish me for wearing it last week. criminal laws are only prospective. Now, there's some controversy in this area because things like the sex registry, meaning someone's been convicted of a sexual assault type charge or sexual inappropriate, I don't want to get, whatever the wrongfulness of sexual behaviors that we can think of. They do their time, they get their punishment, they're released back in community, and then later they pass a law saying, as a result of these certain kinds of convictions, you might have to go in a sex registry. And people say, well, that's a violation of the ex post facto. You're punishing me retroactively for a standard that wasn't applicable at the time that I allegedly did the conduct. The courts have said things like that aren't necessarily punishment in nature. They're more prophylactic to ferret out future crimes and to protect society. I don't know if I buy it. I mean, well, I'm a criminal defense attorney, so I'm thinking like civil lawyers. But there's another one also, too, with certain OUIs. You get a certain number of OUIs, you operating under the influence of intoxicating liquor, you might have to put on a breath test machine right in your car in order to start it. It monitors your breath. And people say, well, my first conviction was back in 1980s. It never had anything on that. So how can you incorporate my acts of the 1980s into a law that was passed in the early 2000s? And the courts have basically said it's not punishment to put on an $800 unit on your car to monitor your breath test. And so retroactive punishment as discernible from really retroactive protection of the public is a fine line, and I don't always buy into it. Just an example, not to get it, since we're talking about sexual crimes, might as well keep going. There was a situation in Boston where a guy got arrested I think it was on the T or in the subway. He was trying to take pictures up women's skirts, and he got arrested. And a friend of mine pictured him right behind me over here, just passed away, as a matter of fact. He was not a lawyer, but he was always interested in law. And he goes, "Hey, Jimmy Kid," he called me. He was a little with me. He said, "Jimmy Kid." He goes, "What do you think that guy's going to get for that?" And he always thinks I'm being facetious. I said, "I don't know if what he did was a crime." And he goes, "Oh, come on, what are you, some kind of pervert or something?" I said, "No, I'm not saying it like that. I just think it has to be articulated as a crime." And sure enough, what did they find out? The legislature didn't actually have anything on the book specific to that conduct. And they came around within like a week or two period of time, passed a new law dealing with certain privacy expectations and upskirting type legislation, if you will, for lack of a very colloquial term for it. And then my friend says, "Well, now he'll get punished." I'm like, no, he'll get punished if he does it again in the future, but he can't be punished for that past act. That was true of like drug laws for a long time. Like cocaine wasn't always regulated. Back in the 1800s, marijuana wasn't always regulated, so you couldn't be retroactively punished for that when the law came into place. You had to stop doing it in the future. And I'm just trying to see if I missed anything else from Article 1 is just so chock full of information. A bit dry, I think. I'll put up a video from scholars that do a much better job on it than I do. You're just responsible for reading through it and knowing some of the big issues. Got to put up something on McCullough, got to put something up on Ogden to really show the expansiveness of what Article 1 gave the legislative power to do. But they don't have the power to do everything. They tried to create a law that no guns can be kept within a school district in the Chicago area. That got shot down because it wasn't inherent in the Commerce Clause, wasn't inherent in the Taxation Clause, or the General Welfare Clause didn't incorporate the intent of the framers. So that got shot down. Another one, just way off track, and I'm sorry I'm going so long in this video. Somebody might remember Terry Schiavo. This is a woman who was on life support down in Florida. Her husband wanted to basically take her off extraordinary medical care, let her perish. And a lot of people wanted to fight that. So they went through the Florida court system. Then they went through the federal court system. Eventually they said the husband has a right to make those determinations with her doctor if her doctor doesn't think she's viable. Some people were outraged over that in our society. And so the federal government passed a law. George Bush, the younger, signed it, basically keeping her alive and keeping her on life support. Well, they appealed to the Supreme Court. And guess what the Supreme Court said? It's not about whether the law is a good idea or a bad idea. It's about whether or not Congress has the power to create such a law. They don't. And so the law was a nullity, is unconstitutional. So the court has interpreted the powers of Congress very expansively. Why? Commerce, taxation, the regulation of coinage, all of those things get great powers, and it's even greater by the court's interpretation of the necessary and proper clause. Never forget the necessary and proper clause, the so-called elastic clause, expanding the power of the legislature. But they were considered to be the most important branch of government. It's pretty much it in a nutshell. I went a full hour. I apologize. Hopefully you get something out of it. I'll put up some of the material as well in a new assignment for week 3. Be well.